point, we have a daughter in foster care, and I have no family support, and I depend on him for support. We have visitation with our 8-month daughter in foster care, and I don't have any family support, so I look up to him.
What don't you understand?
Okay, I know I'm in violation of the no contact with me taking her to the actual hospital and do what I did, but I can get proof of that. But I'm saying, what you saying, you're denying the bond?
Welcome back to Kangaroo Court Law, and an interesting moment in the world of virtual justice. Today, we revisit a case that touched hearts and sparked conversations. In our previous feature, we introduced you to a tense courtroom dynamic where a female victim found herself at a crossroads. She longed for her perpetrator's release, as she depended on him for financial support in caring for their foster child. Today, we bring you some closure with the sentencing phase of this emotionally charged case. Will Judge Cedric Simpson choose to release the defendant with terms and conditions? Or will he bang down the gavel and keep this man incarcerated? It's time to find out.
Court does call the case of People versus Marcus Murray.
Caitlin Kirby on behalf of the people.
Yes, Your Honor. Thank you. Zachary Hallman on behalf of Mr. Murray. Marcus, if you can hear us, please take your or just announce your name.
I had to, for the record, my name is Marcus Murray. I had to wait. She told me to let her know when I was get called.
You're all good. The court, just for the record, Your Honor, we have not entered our substitution order. We are going to wait because we hadn't had a chance to hear directly from Mr. Murray until this morning. We have been talking to a family member of his. So I have talked.
I received counsel.
Sure.
I received with electronic signatures.
Okay, you did receive the substitution order?
Yes.
Okay.
And I'll sign it.
Thank you, Your Honor. I just wanted to make sure that was okay because I saw Ms. Peretti was logged in, but I'm sure she has other matters before you as well.
Yeah. No, I have it.
Okay.
All right. This matter is currently set for bond violation here.
And Your Honor, actually, the defendant admitted to the bond violations on September 8th.
Oh, it's a sentencing.
Yes, yes.
Your Honor, and also so that you're aware, Miss Marcia G is also logged on. She is the complaining witness in this matter, I believe. And let's see.
That's true.
Marcia, if you could just unmute yourself and let the court know that you're here, or the prosecutor.
And Your Honor, for the record, she is here. I don't believe she needs to unmute. We're here for a sentencing. He already admitted to the violations.
Okay, just letting the court know.
Yeah, I see her.
Okay.
All right. Anything you want to say before I sentence him on his violations?
Your Honor, he admitted to the violation, as you heard from Ms. Kirby. And I think, just not to beat a dead horse, but it is my first time appearing in front of you, Your Honor, on this matter. I have known Mr. Murray, though, for some time. I've represented him before. I've gotten to know him. I know Ms. G as well, I will say for the record. And I know that this situation was a one-off. Mr. Murray, I believe, when he pled guilty, explained that the only reason he had any communications with Ms. G in violation of the court's order was because there was a medical emergency at the time. Ms. G is the mother of his child, and he shares custody with her. And at the time of the violation, he was aware of the court's order and would not have had any conversations with her if it wouldn't have been an emergency situation. That testimony has been backed up by Ms. G as well. And I believe and I don't want to put words in her mouth, but I believe Ms. G would testify to the court that she contacted Mr. Murray on that occasion. And that's what led to his violation. Your Honor, he's been in custody now for, I believe, more than a month. And I may be wrong on that, but during that time, he's not had any communication with his child. Of course, he's obeyed the court's orders, had no communication with Ms. G at all, has had no violations, and has had no violations to speak of, besides the violation that we're here in front of you for today. I think that his time in custody and also his the last week or so, there's been some sort of issue where in terms of communication in court or in the jail, where communication has been difficult. Like I said, I was just able to directly talk to Mr. Murray for the first time as of this morning. But I do know that him being in custody is not being looked favorably upon by the Lincoln Hall of Justice with regard to the custody of his young child. And I do believe that he has especially if you give him a chance to tell the court a remorseful heart for his violation and a reasonable explanation, Your Honor. I think the court would see fit to give him a chance on bond, and even if Your Honor would be willing to set a high personal bond, you would never see him in front of you for another violation. And I say that because I know my client, but also because I've heard from the complaining witness, Ms. G.
Ms. Kirby, is there anything from the people before I hear from the defendant?
No, Your Honor, I believe that the proof was put on of the violations and the defendant admitted to the violations. Ms. G was not under a no contact order, so she could contact the defendant all she wanted. Although I would say that when we were first here about the violations, it was because she needed a ride to the hospital and it was an emergency situation. When we actually had the hearing, there were numerous jail calls, and it was that he didn't know that he wasn't allowed to speak to her from jail. I honestly, I have problems with both the reasoning, but the violation was admitted to, and I would just ask the court to sentence him as the court desires.
Mr. Murray, is there anything you want to tell the court before I impose sentence?
I apologize, and I've never been through nothing like this before. I was basically, my health and my child is what I'm worried about. And when I got called on the medical emergency, I wasn't thinking. I apologize to the court. And as far as me, when you asked me to present documentation due to HIPAA, only people that can actually get those documents is me and her. And I've been trying to get her to take care of a lot of personal things. For me, again, I wasn't thinking. I apologize. It was just basically me thinking about my daughter and trying to do the right thing. And now I missed like several visits, and I have to figure out some kind of way to straighten this whole thing out. Through the crisis, they straightened her medication out, and then I was supposed to speak to her psychiatrist. We was having a meeting for a new game plan. I have a youth group that I counsel. It's hurting a lot of lives, me being in here, Your Honor, and I apologize tremendously. And I'll never be under the court again for anything. I am not a bad person.
Well, my issue isn't that you're a bad person, and I don't necessarily think that you are. I think the problem here is that you had the one violation, you went in, and then problem is, what'd you do? You started then making calls. And so then you have
hold on,
other
Marcus.
Mm-hmm.
And it leads me to question whether or not you will and can conduct yourself appropriately if I let you out.
I promise, as a God above, I will do whatever you ask me to do. I am a person that I have a lot of business to take care of, and I'm putting my life together for my newborn daughter. I miss my 10-month-old daughter, and it's not doing her no good for me being here, honestly, or my youth group that I do counsel. And I can bring paper or send email paperwork of all the things that I do in the community outside of this mishap.
And I think, Your Honor, if I may, Mr. Murray understands now that once he was in jail, that didn't change the order. Yeah, I think that he thought, and it was his mistake, and I'm not saying that he wasn't advised properly at all. That's not what I'm saying. I'm saying he was in a state of stress, and he was thinking about his daughter first, and he understands now that he could have conducted himself differently once he got into custody. And he, of course, though, I think we can all understand, was thinking only about his newborn at the time. I would suggest, Your Honor, like I said, if the court is concerned, he's not going anywhere. His newborn daughter is here. He's tied to her. If the court would be satisfied by setting an extraordinarily high personal bond, I know my client, I've been talking to his family, like I said, he wants to address this matter, and he is very sorrowful that the court has gotten the impression that he didn't adhere to the court's orders, because that is not him.
Sentence you to 20 days, Washington County Jail, credit 20 served. I'm going to give you a chance, Mr. Murray, but if you mess up, you're not going to be back.
Thank you, John. Thank you.
No, don't thank me yet. Set your bond at a $25,000 personal recognizance bond. Defendant is to be placed on a GPS tether prior to release.
Thank you, Your Honor.
Thank you. This matter will continue to the jury final settlement conference October 13th, 2023 at 9 a.m. And jury selection, if necessary, October 16th, 2023 at 8:30.
Thank you, Your Honor. Have a good day.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.